बैक कैमरा
हाँ बैक कैमरा ऊपर है ऊपर से कोना में दिख रहा है बैक कैमरा हो गया
हाँ
हाँ आपको लाइव ले लेते
she is not coming even in mediation at Supreme Court. Yes, because she is not coming, she is residing in Delhi and she is not coming because she is not residing in Delhi.
अच्छा आप ही का फोटो आ गया हाँ ठीक है लाइव आ गया है ना साउंड नहीं है
साउंड आएगा वो स्टैंड है स्टैंड लगाओ
कम बोलिएगा लाइव चल रहा है आवाज आपका आ रहा है
Otherwise, the mother DD is ready. The registry is not taking up our DD mother because of the direction mother.
इससे तो इसमें लगेगा कैसे हाँ बोलिए दिख रहा है अभी ठीक है ठीक है तो सही लग रहा है मोबाइल पे तो सही दिख रहा है और मोबाइल एक मिनट अरे तो भूल गया क्या खुल गया निकल गया
टूट गया सर
हाँ
यहीं पे यहाँ पे लगता हूँ
अरे तो क्या मांगे
करना पड़ेगा
क्या हम रखते हैं इसको खोल दिया हाँ हाँ, अरे वो स्टैंड का वो सही नहीं है, वो टूट गया। पकड़िए, इसको हम कर देते हैं, ठीक है। इतना ठीक है ना? एक मिनट, थोड़ा सा वेट करने बोलिए सबको, हम करते हैं एडजस्ट इसको।
Milord, here the plea is, Milord, the council, the petitioner has not been getting any legal assistance there. Nobody is
क्या
ready.
स्टॉप कर दे, फिर से करते
That
हैं
can be cured, but that
क्या?
doesn't mean that a criminal proceeding involves the, this is an investigation
नहीं,
by the
हम थोड़ा
police,
सा
not
इसको
a
एडजस्ट
complaint.
कर रहे हैं ना।
The
एक
matter was listed in court, Milord. He had hired an advocate. The advocate of record concerned here, Milord, had appeared in the Jaipur court, Milord. He was manhandled there. He has said this in the grounds in the transfer petition. If your lordship may kindly see, Milord, may I just read the few grounds if your lordship may kindly permit me, Milord?
Yes. Normally we don't
वो
trust
देखिए तो जरा सा।
Milord, but here, Milord, it is the case is, Milord, the brother is
सिखा
a
रहा है।
lawyer there, and I do not want to say, but father is also, Milord, in a position where.
maybe.
So, please, Milord, Milord, may I just take your lordships to few grounds, Milord? Page 5, if your lordship may kindly see, Milord. Milord, the first ground I'm seeking that he's not getting fair trial, is being hampered, and is being deprived of effectively participating in the legal proceedings at Jaipur solely for the reason that the complainant
कैसे?
mother is a
दर।
practicing lawyer, and father is also there, and are therefore highly influential. Then next, Milord, I'm saying none of the lawyers had been willing to represent the petitioner before the court against the complainant, therefore. Milord,
I court will provide the
I'm only saying, Milord, I'm only saying one thing, Milord.
legal.
Milord, I'm only saying one thing, Milord. If your lordship may, Milord, allow this application for imprisonment, Milord, the respondent can come here, Milord, and the mediation can take place. Milord, Jaipur
ठीक
to,
है,
Milord, your lordship may kindly see, Milord, Jaipur to Delhi is not much
ठीक है अब।
distance. In a day's time, morning she will come, in the evening she can
No,
come.
no,
And I'm ready to pay also, Milord. Milord, there is only one aspect, if your lordship, Milord, a congenial atmosphere will be here in Delhi, which is not there in
ठीक है,
Jaipur, Milord. If your lordship may kindly consider, Milord.
cases without the transfer the criminal.
सीधा
Milord, your lordship,
If the petitioner is appealing that
अब
he may not get the criminal
ठीक है।
assistance, he may approach the legal aid committee.
Milord,
And even the High Court may also consider the prayer for
ठीक,
even legal assistance.
when the
Right.
lawyer was being manhandled in the court itself,
ठीक है।
the judge itself left the chamber for the chambers, Milord. He did not sit in the court and
No,
he
no,
did not.
don't make allegations
ठीक
like
है,
Milord, this is what, Milord, that is why the advocate on record was not here. It takes some time also, Milord. He had appeared in personally. If your lordship may kindly
sorry,
consider.
madam, we have password.
I appreciate, Milord, if your lordship makes, Milord, opening, Milord, matter can be considered,
फिर
Milord.
छेड़ना पड़ेगा।
Milord, your lordship had issued note and also stayed the proceedings.
So what?
So if lordship,
See,
Milord,
Ms. Namta, transferring a criminal proceeding we never do.
difficulty your lordship may kindly, Milord, see, I'm not getting a fair trial. I'm
देखिए,
not
ठीक
getting
है।
a
See, this
Will
is
you
the
present?
usual thing which you said.
फिर
This is the usual thing. Whatever you have to, it's this little bit of discomfort. You go there. If all this were true, you would have filed a complaint.
Well,
That's not the case.
And you engage the lawyer from Delhi and
Exactly.
through video conferencing it can be contested.
Milord, there is one aspect more if your lordship may just consider, Milord, one aspect. May I just point out, Milord? Milord, in the teeth of your lordship judgment, which was pointed out to the learned judge, Milord, he has still passed an order of, Milord.
You challenge
Milord,
it.
that I'm not, Milord, that
That
is
cannot
kind.
be a wrong order cannot be a ground to transfer the
Milord,
proceedings.
Milord, the only I'm showing is the bias, Milord.
Sorry,
and
next.
it's the-
This gentleman is in bail in.
Just, your lordship may record that I may be permitted the VC appearance there if possible, Milord. That may be. The judge can consider, Milord.
That is always so.
Your
In
lordship.
investigation, we cannot say through video conferencing. Correct? Only in trial we can say. Yes.
And, but this gentleman is in custody for about 5 years, 4 years, 7 months to
You are convicted for 302.
Yes, not
And your
4-year-old.
and your application is rejected in 2020.
Yes, but in fact, I must say this, while granting leave, it was rejected. But he's a 64-year-old gentleman, not good health, and wife is also not keeping well. Not I'm taking a plea on grounds of
No case is without releasing the petitioner on bail pending appeal.
at this stage.
Not there is nothing like.
But my lord may say this stage, not if I need to come back tomorrow. Lord.
No,
Withdraw
come
it.
to-
Then you withdraw it.
I'm not. You can't give me to punishment.
What is? So we must say, yeah.
My delay can't be, my delay being on my feet not can't impact the man. I should have made this request. That
Do
is
you
my
want
lapse.
do you want to go into merits of the case?
No, what I'm saying
Huh?
is my request, it's my delay.
Very well reasoned judgment by the High Court. But still, as the appeal is pending, we don't want to say
I
anything.
completely understand. Not alarmed. Lord, at this.
Thanks, permission.
Grateful.
Item 12.
May it please.
We have moved the application for because two orders. First, Lord, on 13th December 2018, the Lordship granted a conditional order. Issue notice in the meantime, interim protection from arrest is granted to petitioner subject to condition that petitioner shall deposit 50 lakhs to the credit. Because Lord, the complainant, his whole lifetime savings is defrauded. He is 80 years old man. And Lord, the next order, Lord, on 30th April 2019, Lord, High Court declined the bail. They have come the interim protection. Then Lordship modified this order. This was on a misrepresentation. Kindly see that order of 30th April. The petitioner has submitted that as per order dated so and so, petitioner is not in position to mobilize the fund and deposit the amount. Learned Counsel further submit that petitioner is pursuing a PhD course. She may be granted interim protection without condition of depositing the amount. Now, Lord, in the trial court, the submission was that she is a PhD. And here it is said that she is pursuing this is how she misled the court and got this unconditional protection, not the company. Not the charge sheet is filed, it is being adjourned again and again on the ground that matter is pending in the Supreme Court. 3 years trial has not proceeded.
That is okay, counsel. But subsequently, the very bench modified the order of deposit of rupees 50.
On a misleading, on your
You
lottery.
want this you did. This should be turned into a recovery proceeding.
Lord, that's what Lord Lordship may kindly just consider this.
Mr.
For this complaint,
There has to be some proportion.
Anyway,
2018.
she has cooperated.
She has cooperated. The charge sheet has been filed.
No,
Has charges been framed?
Stage of trial.
Have charge? Yes, it's at the stage of trial. You are not in session. You are not in session. It is the state.
please, Lord, just consider this, Lord. I understand, Lord, it is a 420 matter, and Lord, money.
This is not a reckoning.
I understand. May I just point out only one thing? Lord, the complainant is an 80-year-old man, Lord, very sick.
Ultimately, you want
It is
this to
his.
be a suit for recovery. Have you filed a suit for recovery, Mr. Sisodia? Have you filed a suit for recovery?
Mr. Counsel will say the trial is expedited.
Lord, it can be done in 6 months, Lord.
Please say one.
Please do it for
Considering having heard the Learned Counsel respective parties and considering the fact that the interim protection granted has been granted in favor of the petitioner, in favor of the original petitioner, this accused has been continued till date. And it is reported that in between the charge sheet is already filed and even the charges are also framed.
Trial is also.
And
Trial is not going on.
Trial is not on.
Trial is commenced, Your Lordship, but witnesses are already found.
All right.
we made the earlier order of interim production absolute and directed in case of arrest of the petitioner in connection with the FIR institution. She may be released on bail on the terms and conditions that may be determined by the London Trial Court. But in the facts and circumstances of the case, and as it is reported that the original complainant is within 80 years, direct the London Trial Court to finally conclude the trial at the earliest, but and preferably within a period of 1 year from today.
Lord,
We can't precise our judges also.
Not
They are also overburdened
please.
with these prison applications and these programs.
13.
Lordship. So, item 13, there are
two interim applications by the two respective petitioners before your lordships, both on medical grounds. Your lordships would take up first item number 1, which is criminal MP 109767.
The 2019 SLP again.
Yes. So this is today only for interim bail for certain period on account of medical condition. So far as number 1 is concerned, that is Yogesh. Your lordships have been kind enough on earlier occasion and granted an indulgence. I've explained that in my application as well. This is only for the purposes of IVF treatment. On last occasion, when your lordships have granted indulgence, no case for that. Interim bail is may I just raise in that case, in
Okay,
that
appeal will be coming. SLP, yes.
Appeal in due course, it will take some time. May I just...
No, due course means it will be, we are now special bench is there now. Criminal bench.
May I just try to clarify myself on the application? Only for a minute. I won't take age of both of them would subsequently may not permit even the medical treatment as well. That is what the anxiety is, and that is why
Subsequently move for earlier hearing of the appeal.
I take it that your lordships are rejecting 109767.
Yes.
Then could your lordships take up the other one, 158229? And if Manoj should consider this favorably here, his father is at as an advanced stage of liver cirrhosis, has been advised.
When the operation, then you come.
So there can't be a date fixed. That is the difficulty. Manoj, I have explained everything in my application. Could your lordship just take up?
Look into the seriousness of offense counsel. You read serious.
Manoj,
Very serious.
I understand that. Could that not be considered at least for limited time, because I have to arrange a donor, I have to make arrangement for my finance. Manoj, may I just highlight one rule? Only for a minute. I won't take much than that. Manoj, even as per Delhi prison rules.
When the murder was committed, where were those rules gone?
To the wind, my lords.
Rules over the rule, Mr.
I am just trying.
2 years crime was committed.
Because I am not in a way trying to point out the constitution of the rules.
Too much high, Mr.
No, Manoj, I just want to beseech. Manoj, I am just trying to beseech your lordships on the point that being a convict. Only for a minute, one sentence and I am done. Only for a minute, Manoj, only for a minute. I am so sorry for this. Because under the prison rules, he is entitled for parole being a life convict on the ground of illness of family member. Because here, that is the precise ground. Now, what has happened here is this. Since my appeal leave has been granted by your lordships and it is pending here, they are not considering my applications on medical ground as per the rules as well. If that could be clarified.
You challenge it.
No, that is why I have challenged, but then could your lordships take up the third petition there? Because I have precisely challenged the virus of the rules.
Second, now third.
No, in the third one, then I am challenging virus of the rules. Could that be considered at least by
Virus of the rule. No.
Yes. Could that be considered for a minute?
Sorry, that application also. You cannot challenge by way of application.
But so far as this second
He wants to challenge the rule.
person pertaining to
It's a writ petition or?
it's a writ petition, because my plea is not being considered
We
any.
are not dismissing it. We are keeping it pending. For
In the writ petition, they have filed a reply and they say that my contention is nothing but can be read into the rules. If your lordships could take up their counter for a minute.
We'll take up that matter after some time.
As a last indulgence.
Extra counseling over.
Your lordships have already said that as and when I get it, what is there to laugh about? I'm just making one small request. Your lordships have said.
Use your temper counseling.
No, but then it is none of anybody's business to laugh like this.
Yes, you are right.
That is like control. Ultimately,
Certainly, I have to understand that, but then at the same time, because I'm just trying to.
Anyway, we have passed the order.
Trying to place my claim before.
We have passed the order. I said, lead petition खाली adjourn कर
Yes,
दीजिए.
yes.
My lords, your request.
Yes.
चलिए next.
So far as liver cirrhosis is concerned, your lordship said that I will have, as and when I get a date,
Correct. You can file a
I will
flex.
have a liberty. If that be observed tomorrow, this order should not come in my way.
It will never come. It will never come.
Very well. I'll leave it at that. My apologies also.
Application for cancellation of anticipated bail on cooperation by the accused. So this is 3 years back, the order was passed to directing the accused.
What is the?
Thereafter, some order was passed, sir.
Yeah.
See the order dated 2/12/2019.
That's correct. So I have no instructions on whether he has cooperated with the charge sheet is
What
filed
is
by
the
this.
charge
sheet is filed.
Charge sheet is filed.
I have no instructions on that right now. I just take the
Charge sheet has been filed.
charge sheet already filed. Might see that. I had no instructions about whether the charge sheet is filed by this.
It is fine. But he's making a statement.
Charge sheet.
You have the date of the charge sheet? All
If the charge sheet is not filed, whether you
I will move ahead.
come move an appropriate application.
In fact, you can go back and check at the national data grid and tell us.
Pilot can pass it over, we'll just confirm in the meantime.
That was
As for the state, I'm not a complaint.
complainant has already withdrawn.
Present application has been preferred by. The state for the extension of the bail granted. The original petitioner, the full Praveen Chandra Parekh, which was granted by order dated 9/4/2019. It was the case on behalf of the state. Then after obtaining the order of bail dated 9/4/2019, the accused is not accused was not cooperating with the investigation. By order dated 2/12/2019, this got directed the original accused to appear before the investigating officer on 6/12/2019. It is reported that thereafter, it is reported by the Lieutenant Counsel accused. Thereafter, the investigation is complete and the charge sheet is already filed. The Lieutenant Counsel of the state has stated that he has no further instruction in the matter on whether the charge sheet is filed or not. Is that it may. We refer the statement of the Lieutenant Counsel and accused that now the charge sheet is already filed. If that you have the matter, the present application for cancellation for bail stand disposal.
Please.
My statement is on instructions.
You have clarified your statement now.
Please.
Wait, please. It was pursuant to your lordship's order, because we appeared before the investigating officer on 4 dates, 6 to 7 hours per day, Milos, we've been interrogated as per your lordship. Whatever documents were asked of us, we've supplied all the documents, and that's how, Milos, the case stands.
My instructions are that she has been giving evasive answers, sir. She has a protection from this honorable court, we have not.
What evasion means? You want the confession? Then what do you want?
Like, for example, she has money in her accounts. Now, those monies are unaccounted for because these are the allegation is that she has taken cash with us and she has misappropriated cash. She has amounts in her account. Now, what she says is that it is for a property which they have to sell and they've already received the amount. They've not sold any property.
You find out, Mr. the source of the other properties. It is for the investigating agency to find out, no?
That's right. It's for the investigating officer and the agency to find out what's the truth behind those entries. And she has FDs for more than 50 lakhs, which she initially did not disclose.
So?
I'll explain, Milos. There's one entry, this is lack of Milos accounting knowledge. There's one credit entry, there's one debit entry. They Milos add up the credit entry and the debit entry. They say there's just one transaction. How did you get this 25 lakhs? I give them an agreement to sell of my property with a buyer. They examine the buyer also. The buyer says, yes, this is how it comes to her account. Then there's a debit entry because the transaction did not fructify. The money goes out of the account. Now they add 25 plus 25 and they say 50. That's the only allegation against her. And
Total allegations are rupees 1.10 crores.
1.10, today it is 42 lakhs. 1.10, when they do their reconciliation of accounts, today in their latest audit report, they say 42 lakhs. In the latest audit report, I can show which is displayed on their website also. So today 1.10 is 42. This lady leaves the organization 5 months thereafter. She's given NOC and everything. And I have, my lords, placed
No, no,
four
you are not-
quarterly
you are not-
on merits. 4 quarterly when, my lords, she was 8 months pregnant. She was
Charge
called
sheet
to
is
the
filed.
police station.
When you will file the charge?
IU is here. I must state one thing, Manoj. She leaves on the pretext that she wants to shift to Roorkee, Manoj, with her husband, and that they're buying a flat there. They've never shifted to Roorkee. They are staying in Delhi, Manoj, and then she says that we are planning to buy a house near IIT Delhi, Manoj.
How it has any relevance with the exhibitory case?
Manoj, I'm saying that everywhere when she's being interrogated, she's giving answers, Manoj, which are
See,
absolutely
we don't know what kind of answers you want. Even if she confesses the whole thing, you can't, that is inadmissible.
Section 25 of the Evidence Act.
एक मिनट में ऐसा है कि वो बोलता है
Proceeding for recovery.
Nothing. They've now realized, my lords, that all this allegation today is 42 lakhs of reconciliation.
we are not concerned.
We are not, that's not the point.
Whether 42 lakhs as on today or what.
And I have filed a sexual harassment, my lords. My FIR is prior in time.
No, Mr. At the relevant time,
Yes.
he protected you because he delivered a
I'm grateful.
That was the
You know,
reason that
absolutely.
weighed with us on that day.
Yes. I bow down.
Yes,
about a month. Charge sheet will be filed within 3 to 4 weeks.
They've,
Exactly.
deeply obliged.
In the meantime, you control the investigation and file the case. But you don't expect, Mr.
Because
that
perhaps-
she may confess and give the answer whatever you like or reply. Hello, next.
Deeply obliged.
Perhaps I'm praying for a week's accommodation. We've just received a counter affidavit.
Hmm?
Payment. So I'm praying
What?
for a week's accommodation so that I
For
can,
what?
for filing the rejoinder.
For rejoinder, and what is this? This is also a bail matter. This is all bail. Considering what has been stated in the counter which you need to traverse.
There are some other matters also pending.
Yes,
They are agent to 3rd January.
connected matter
Connected
is
matter.
listed.
Connected matters.
This may also be taken up with that. In the meanwhile, I'll file the
Pick
rejoinder.
up on 3/1/2013 2023. We heard which SLP criminal number 9666 of 2021.
Deeply.
Oblations.
On 19th of May. It's essentially a dispute between two real brothers, my lord, because the father disowns the complainant. And in that grudge, my lords, there's a FIR, which is a cross FIR against my DDR entry. Now the investigation is complete, my lords. In the counter affidavit, they say I have joined the investigation also. But they claim that I should give the so-called weapon of offense, otherwise this will be deemed to be non-cooperation.
You have to find out counsel. You have seen your counter counsel. When you say that he is not giving the showing us the weapon, then it is non-cooperation.
And 55, they say I have joined the investigation.
Lords, the Honorable Chandigarh High Court rejected the bail petition on the same ground because he was not cooperating. Lords, he was not giving proper answers to the.
We have seen your counter.
Yes, my lord.
You are saying that as he is not showing the place where the weapon is, correct? So
What is your job?
It is your job,
Lords,
Mr.
but recovery is to be made, my lords.
Okay, but he cannot say, he cannot disclose. You cannot compel him to disclose the weapon unless he voluntarily states so.
Lords, but custody.
If there is no recovery, if there is no discovery, then there should be recovery. There is a distinction, no, between discovery and recovery.
My lords.
And one or two real brothers, my lords.
By earlier order.
There is a civil suit also.
Yeah, and father has disowned him actually. That's
Dated 19 May 2022. This court has granted the interim protection against arrest to the petitioner. But he requested thereafter the petitioner has cooperated in the investigation. The charge sheet is filed.
No, my lords.
Investigation
Is to be filed, my lords.
Cooperating in the investigation. Will Maravan take the case on behalf of the state? That as the accused is not cooperating in recovery of the weapon, used in commission of the offence, the aforesaid cannot be said to be a non-cooperation on the part of the accused. It is ultimately for the investigating agency to recover or discover the weapon used in commission of the offence. Considering the aforesaid overall facts and circumstances of the case, we with the earlier order dated 19/5/2022 absolute and direct that in case of the arrest of the petitioner in connection with the FIR in question, we be released on bail on the terms and conditions which will be determined by the learned trial court. Present. It goes without saying that otherwise the petitioner shall cooperate in the investigation. With this present as it be established for law.
Date for response.
18.
I know.
There's a letter circulated at decision. There is a letter has been circulated, but
So there is,
Better.
earlier also the adjournment was granted, counsel.
earlier it was granted on the pretext that there was an argument on the behalf of the senior counsel that the matter that the car in which he has taken the lift, he's not in a.
He was the driver. Where is the question of
No,
right?
Millards, he's not a driver, Millards.
That's what the.
Anyway, that was the allegation.
No, Millards, he was not a driver. Even as
Anyway, 23 kg ganja.
Millards,
Bolero.
no, Millards, Baleno, Millards, Baleno, not Bolero.
Are Bolero, mister.
Baleno.
What is there in the vehicle, mister?
No, Millards, Bolero is a different vehicle. Baleno is a
Are
different.
Bolero, counsel.
That is not. That's not relevant.
No, Millards, this is a matter in which Millards, he is taking the lift from the. I have filed an affidavit in which Millards, if Millards.
That is your defense, mister. Affidavit is a defense.
Millards, this is what Millards, even as per the allegation in the FIR, Millards, even as per the charge sheet also. If Millards may see the page number 38, Millards.
Yes.
Page number 38 talks about there is an information of one Tata Ace truck. Last third line, Millards. Third, fourth, fifth line, Millards. He received the reliable source information. Millards have it.
Yes.
Yes.
He received the reliable source information that one vehicle having registration number this Tata is carrying huge quantity of contraband narcotics. This was proceeding towards Siliguri side from Kuch Bihar via this. Now, Millards, in the entire charge sheet, Millards.
So there was actually not one. There were two vehicles.
Two vehicles.
Vehicles.
One was truck.
One was truck, absolutely right, Millards. One was truck. The information is of a truck, Millards. I was not even a
So
driver.
you are a bonus.
No, Millards, I was not a driver of the Baleno car, Millards. I was a bypasser who took a lift from the Baleno car, Millards. This substance has been recovered from the Baleno car, Millards, not from me.
Okay.
It's not in the active possession, Millards.
No case is allowed to release the case.
This comes after notice, Millards. Praying for bail under 436A, second proviso, Millards. The petitioner, Millards, has undergone the maximum permissible sentence under the IPC as an under trial, Millards.
11.
Millards, as
3 years
per
to time.
Millards, as 4 years and 1 month now, Millards.
Now 4.
Yes, Millards. 4 years and 1 month, Millards. Millards,
Three charges.
take your lordship to the charge hearing order.
charge is framed only against the
Yes, my
under
lord.
the IPC?
Yes, my lord.
Yes, correct.
PC Act
No,
charge
my
is
lord.
not framed?
Milas, there was a supplementary charge sheet that was filed under the PC Act, but the Sessions Court did not take cognizance, and I was not even named in the supplementary charge sheet. That's on record, my lords. If I may just take your lordship to the charge framing order for a moment.
Only under 414, no?
Milas, 411, my
What
lords.
happened was,
411.
In one way.
but what happened was when we filed the charge sheet, because 409 also was there. But unfortunately, charges are not framed under 409. So my learned friend is right regarding 436 capital A. My only request is, Manoj, the High Court hasn't considered this aspect at all.
But we are considering the council, why don't we?
So the only thing is, if your lordship is inclined to enlarge him on bail, he is not a resident of the state of West Bengal. Our only apprehension is trial is going on. We had to actually apprehend from Rajasthan. So now the problem is, if your lordships were to bind him down to the state during the pendency of trial,
1 minute.
because I would only urge your lordships, if your lordships are inclined to enlarge him on the principle of 436 capital A, is if your lordship can bind him down to the state of West Bengal during the pendency
Mr.
of
Fernandez, please tell us today if he has served the maximum,
yes.
we'll bind him down, but where will he stay? What is
He
his
can report to the IO concerned once a week, once a
We will
fortnight.
say that agent, subject to condition that during the trial, he may cooperate, correct, and shall remain present before the trial court as and when
Yes.
Yes.
on the every day
Every
of
day,
hearing,
yes, he should be
except
present.
specifically exempted by the court. So that will serve the purpose.
Once that happens, then what happens is, so then they keep
Then you
on
tell
doing personal
where
exemptions.
you can just find out. The other via media is where will you go? Where is
Yes.
your normal residence?
Keep him at the IO.
Where is it?
It's in Rajasthan, my lord.
So we can say
But
that he will
if I may just also submit.
that he can just consider this. You may report to the concerned.
Milas, he's already undergone the sentence. Even it's a maximum sentence is.
We are trying to safeguard the interests of both parties. Please allow me to speak. So let the petitioner report to the concerned police station every 2 weeks so that they are in the know that you have not run away or something.
Yes, sir.
That's all.
What is your address?
Yes, Milits, this is Ganga Nagar, Rajasthan, Milits. Jawahar Nagar, PS Jawahar Nagar is the concerned police station.
It is reported that I now the petitioner has already undergone 4 years and 1 month in custody. The petitioner is charged by the London Trial Court for the offences under section.
411 and 414, Milits.
और आप ही लिखा दीजिए ना?
I'm so sorry.
हाँ?
I was just taking your lordship to the order, Milits.
आप ही लिखा दीजिए ना?
I'm so sorry.
हाँ? What is this impatience?
I'm sorry.
Don't be. Last time also I have said some junior counsel. Don't show so much enthusiasm.
Yes, sir.
It breaks our, you see, link.
I deeply apologize.
The petitioner is charged by the London Trial Court for the offence under section
411, 414 and 120 BIPC. Under circumstances, petition is entitled to be released on bail. Subject. London Council applying the state. However, has submitted that this one is the resident of Rajasthan, Ganganagar, Rajasthan. And therefore it will be very difficult to secure his presence at the time of trial. Good point. The same can be taken care of by imposing suitable conditions by releasing the petitioner on bail. Next, in view of the point for the reasons stated above, present appeal is allowed. By agreed judgment in order passed by the High Court is set aside. Petitioner is ordered to be enlarged on bail in connection with FIR public criminal case, the case number 187 of 2018. Into bracket, special case number 2 of 2018 pending before the London Judge Special Court, Second Court at Jaipaiguri, Jaipiguri, bracket complete, on the terms and conditions which may be determined by the London Trial Court. Petitioner is directed to furnish
her present address, which is reported to be Ganganagar, Rajasthan, to the IO in the present case, and that the appellate shall mark his presence every 2 weeks before the nearest police station where he is residing in Ganganagar, Rajasthan. Petitioner is also, appellant is also directed to remain present before the trial court on each and every date of hearing, unless specifically exempted by the concerned trial court. Is this present appeal is allowed?
Yeah, please. Magistrate tribal and Malas within 3 years. Punishment is 3 years, Malas. Subsequently, Malas 406 is added, Malas. We are husband and wife, Malas.
So husband can
No, Malas, cannot. Malas, we are
husband can cause the injury on the head
not at all.
by metal rod. By metal rod.
Not at all, Malas.
Huh? That is what exactly, Mister.
Malas, what I'm trying to say, Malas.
And how many stitches?
Malas, 18 stitches, Malas.
Then 18 stitches, and you are asking for the bail.
Malas, what I'm trying to say, Malas, kindly issue a notice to my wife, Malas.
Huh?
Kindly issue a notice to the complainant as well. Malas, I have instructions to say, Malas, the matter is on the verge of settlement, Malas.
Maybe, Mister, we don't want to see.
Malas, sending me to jail, Malas.
Your wife may be generous, Mister.
Malas, 2 children, Malas, both are living with
No counsel.
8 years and 10 years.
At least we don't tolerate this, Mister, in our society.
No, Malas.
That husband, Mister, cause the injury on the head by the metal rod, correct? With 18 stitches.
Malas,
See, Arrest report survived because she was lucky.
Malas, she has fell down from the stairs, Malas.
Dismiss.
She has fell down, Malas. Malas, kindly consider.
Yes, fell down. Oh,
This is what, Malas, this is what I have said.
what are you talking, Mister? Your defense was that he was in a drunken condition and therefore he caused the injury.
No, Malas.
Don't say this that he fell down.
Malas, this is there, Malas. The drunken injury, Malas, kindly have FIR.
Mister, by falling down, correct, this injury of 18 stitches would not be there.
Malas, FIR is on
Have some defense which can be accepted.
FIR is on page 22, Malas.
No,
One line,
no,
Malas, kindly.
Sorry, counsel.
Malas, one line, Malas, kindly read it, Malas. Page 22, Malas. If Malas may kindly consider. One line, Malas. FIR, Malas, it is only of 2 lines, Malas. Kindly consider, Malas.
No, Mister, no court will grant you bail.
Malas, what the wife says is there was a fight, Malas. She doesn't talk about.
That to anticipate anyway.
Malas, she doesn't talks about the rod, Malas, or
It
anything.
is there, counsel, metal rods.
22, Malas.
Doctor's opinion is there.
Malas, page 22 is the FIR, Malas. Kindly see that, Malas.
Counsel, don't press this.
Great.
It's not a case.
21.
But this is one of those rare notifications where no khasra number given. Just have a look at the section 4 and section 6 notification. And one matter has already been allowed lot where they have not even challenged. This is 5,000, 50,000 acres. All the villages were Lord Balakram as early as Lord in 1988.
What was the relief sought by you?
But I'm in possession.
Award was made. Award was made.
1987.
87 award is made.
No, award, nobody has taken that money. It's lying in the, and the entire acquisition has not been set aside. The argument should have been, or prayer should have been that in terms of Balakram, this notification itself has gone and accordingly no steps can proceed thereafter. Just have a look at what Balakram have listed on record.
Yes.
Just take page 45.
Balakram, then which is that Abheram, to all that full bench, 3 judges of this court.
Say, Lord, I have gone through Abheram very closely. Abheram didn't say that Balakram will be confined to its own petitioner. Because Balakram, the
Balak Ram was a peculiar
also,
situation and
not just have a look at this notification. If your lordships can see that this kind of a notification, can just see 38 first. 38.
where were you in 2006? Till 2016, what were you doing?
Mr. Purchaser
I
is
was
taken.
in possession, I was not.
No, you are a subsequent purchaser.
91.
90,
After Balak,
exactly.
Correct, but after the section 4 notification,
No, but
after
after Balakram,
maybe, Mister, maybe
notification
Mr.
itself had
Council,
been
there is already a judgment of this court now. Correct, followed by other benches also. Justice Gupta.
That judgment will not apply, my lord.
Which judgment? You don't know which judgment.
Your lordships are mentioning the review of Pune Municipal.
No. That is the problem. We have not. That is
No.
also not the problem. Problem is that in Godrej judgment, correct. Subsequently, the view is taken that the subsequent purchaser cannot pray for lapsing of the acquisition under 2013 Act.
I am not praying that.
That is what your prayer, Mister.
My prayer may be wrongly prayed.
No, not wrongly.
I'm saying so, Lord. My prayer need not have been that.
Very well, you can still say, even if you ignore 24(2), still you don't get away from the fact that 28 years later you're going to the court.
I'm going.
There is no basis for the court to have
The land is mutated in my name. I am in possession.
See, in Delhi, anything happens. After
Lords, I beg to appear in 21.1, my lord, if your lordship permit me. My apologies for not being in court, my lord. Please forgive me, my lord.
Mr. Ranjit
Can
Kumar,
I say something in 21.1, my lord?
All are saying the same boat, Mister.
Lord, if I may just say 2 points, my lord, and I will be done with it.
Everything is over, Mister. In much earlier, Mister. This 2013 is not to reopen everything.
No, my lord, I'm not. I'm saying a little different, my lord, if your lordship don't mind, my lord.
We don't mind at all anything.
Lord, what happened?
I have not
What
finished.
happened was,
Mr. Kumar, can I just finish my argument and then Mr. Ranjit Kumar can take over.
Correct.
I am not relying upon the 13 Act for the purpose of saying that my possession should be restored or that I should not be disturbed. I am saying that this acquisition itself, Lord, in 88, as early as in 88, it had been quashed. If that
did you go in Balakram?
I was not in Balakram.
Therefore,
But just the judgment in Balakram. Balakram says all the villages.
Yes, we have to go step by step. It is quashed. But Abhay Ram limited Balakram.
That did not.
Yes, it said it is not in REM. It said it is not in REM. If it says it is not in REM, it has limited it. Number one, Abhay Ram is Supreme Court. Balakram is High Court. Therefore, the Supreme Court, the law declared is that Balakram is not in REM. So it doesn't inure in your favor. If it does not inure in your favor, you enter as a subsequent purchaser, you take it with all.
In difficulty. Then
you are in difficulty.
But Lord Abhay Ram, if your lordship can just have a look at Abhay Ram is not saying that Balakram was not a complete quashing.
The Balakram is not in REM means only those who went.
Even if it is not in REM, but the notification
can't
is
go
part of
behind
all the 7 villages.
And after that, Gurdeep Singh Goban, I mean,
why only those persons?
we have gone into this 4 times. This court has gone into it. Why should it go?
Yes, Mr. Kumar.
Your lordship
2 points, my lord, if I may.
167, your lordship, my lord Justice Ravindra Bhatt has actually that Tarni matter.
I don't know which one. I'm not seeing.
Right, it's on record, Lord.
Maybe.
167.
Maybe, Mr.
Maybe what? So maybe at that time it was pointed out or not pointed out. So
175, please see, not 175. Part of the same notification.
Yes.
P14 in 21.4.
It is also not in REM council, even if it is so.
No, this is order of 17, and this is also a writ petition filed after 20 years. This was listed together. My writ was listed with this
170?
175 P14.
That's not the impugned order, right?
No, that's not the impugned order, but these were all.
All right, so now I'm wiser.
Yes, Council, Mr. Kumar.
Lordship, 2 points, my lord. My lord, in 1980, 11 villages without any description were sought to be acquired under Section 4. 1985, they reduced it, my lord, from 11 villages to 5931 bighas. Thereafter, my lord, so far as the bighas, the award was made, the entire acquisition was quashed. After the quashing of the acquisition, my lord, I purchased this land. Thereafter, my lord, my name was mutated, I carried in possession. And, my lord, the same company, so far as the petitioner is concerned, the same company, my lord, as my friend was just pointing out, at 167 in my paper book 21.1, is a judgment of the High Court where your lordships relating to the same notification as your lordship then were, my lord, have quashed the notification and allowed me to continue with that land, and that order has become final. DDA did not challenge it.
That is on the 24. That is on the basis of 24-2.
No,
Not
but
you. Which
I am
bill is
only
that?
respectfully submitting
Mr.
that
Kumar,
the land,
that
the
is the one
purpose
which,
for which.
that is the one which, that is the one which Mr. Vikas Singh mentioned
Yes,
just
my lord, I am not saying, but it is my lord, I was the same party there, my lord. I was the writ petitioner there. My lord,
Sorry.
one more point, my lord, if your lordship don't mind.
Yes,
I am
sir.
not relying on 2013 Act, my lord. What I am saying is, the purpose for which the land was acquired has not been achieved in 42 years. The land is lying vacant, my lord. There are photographs from the Google which I will show, my lord.
No,
My
no,
advocate.
Mr.
Give it
Kumar,
to your
so far as
lordships.
this is concerned, you cannot challenge after 30 years. That as the land, once the land acquisition proceedings are over, it is complete, then that's an end of the matter.
The question is, my lord, that somebody should have come over and taken possession. Nobody came to take possession. I still continue. The land is lying vacant.
Illegal possession.
If the land is lying vacant, my lord, I should be able to, my lord.
You are also, you will say me the same boat of Mr. Vikas Singh. No cases.
Lordship, please.
Lordship,
Lordship, please.
passed by the High Court. As sir, we are in complete agreement with you taken by the High Court. Both the SFP stand dismissed.
Lordship, please.
Delay for law.
There is no delay in my matter, my lord.
In other matter.
21.1, there is no delay.
Okay.
Lordship, please.
May please. Yes, Lordship. Lordship, this matter pertains to the import of tur dal, pigeon peas. Now, they had been issued RCs in the year 2017. The contract between the parties were otherwise inter se, with by way of addendums, they kept apparently informing DGFT with respect to the changes in the conditions of the contract. The pertinent issue is whether that RC subsequent to the extension of the validity of the main
See that
policy.
Para 105,
Yes, Your Lordship.
does it impose a time limit?
Time limit, that is the point.
That is the important issue, right?
Your Lordship, may I just point out one thing? Because of the effect of the notification.
See, firstly, they placed it in the restrictive category.
Yes, Your Lordship.
Thereafter, then there was a relaxation. Then there was a further,
Yes.
there were two further relaxation. And then thereafter, COVID intervened.
Correct.
So then
It's not the essence so far as
May I just point out one thing, Your Lordship? With respect to this, once it is placed in the restricted category, what happens is that they are only allowed to import a certain amount for the entire.
there were two types. First restrictive, that the notification itself clarified who can, that is if the LC is allowed or it's already shipped, but not high sea sales, etc. Then the second one was further relaxation. What was that further relaxation? I think some further
Advance payment is already made.
advance
Yes,
payment
with
is.
respect to advance payment, Your Lordship,
Now-
you have
now-
actually not led evidence or even suggested that they had applied
Ultimately,
to
it's
the.
only a shipment of 8,500.
then they already imported the
They've already
They
imported.
haven't imported all of it, Your Lordship.
All
They imported 2,000.
It's lying there.
The
See,
order is with respect to those bill of entry.
2,000 plus they said that if they have it, if they import 8,000.
what happens is
you will
today
allow.
you did not allow, which means they have incurred demurrage also.
That is also denied by the High Court.
That too is denied.
Even damage is also denied by the High Court.
Order is of.
You are lucky enough.
I'll rest my case here, Your Lordship.
No case having heard the take also respective persons, no cases without it. No cases in which the accused has been order passed by the High Court. SLC stand.
Similar SLP. 27. 20? Sorry, 23, sorry, yes, sorry.
Lordship, there is a delay of 178 in refiling, Lordship, and again the common order, the
Land acquisition.
from the is disposed of by giving a liberty to file review.
You are falling in which category?
We are the formal Lordship.
Huh?
Category
Read unto
two.
page
There are
74.
3 categories, no?
There are 4 categories.
Category 4.
You are present in which category?
Category 4, Lordship.
No, it's actually there. Yes, para 63, I think you fall in.
Category 4.
So yours was 6083 and 1 2 was taken by drawing Panchrama
2007.
in 2007. Correct.
Lordship.
Indoor development is there.
Free and fair, Lordship. Again, the same common order review, liberty to file review application.
No, review. What is the
What is the review? If possession was taken in 2007.
7? Correct. Taking into consider this one in the case of so-and-so versus so-and-so. Reported in so-and-so. Indoor development. No cases property interest they can order passed by that. That's a mistake. What representation? Possession is taken over by drawing Panchrama. Chalo, right.
Lordship.
Lords, Mr. Reddy is in some bereavement, he lost his elder brother. That's why, my lord, a letter has been circulated. But since it's a contempt, my lord, if your lordships feel that it has to be proceeded.
Sorry?
Mr. Venkat Reddy, he's in bereavement, he lost his elder brother day before yesterday. That's why, my lord, a letter has been circulated.
The way this land had to be allotted to the workmen.
You were required to take instruction on.
That I have
They filed an affidavit.
I filed an affidavit.
You have to hand over possession given.
Affidavit has been filed.
Plots are given.
Not yet. They're asking for 6 months and.
No, 6 months denied, rejected.
Correct.
We said no on that day also.
That's right.
Sir, it's a question of 183 families.
Therefore,
They are waiting since many years.
Lordships may,
Order is judgment is confirmed.
Lordships may grant some reasonable time.
Not reasonable time, sir. We'll grant you 4 weeks time.
Mr. Giri, this judgment is of 21 October.
But I understand. That's why.
And order is judgment is very clear and 183. See,
Yeah.
we grant you 4 weeks time.
4 weeks.
No. Even we are not.
In fact, they have developed land. There was a state.
It's 4 weeks time might be difficult.
Okay, then don't give. We are just sending it to jail.
No, Lord, I'm only praying. Lord, this.
No,
this is
6 months is unreasonable.
Very well, your lordships may grant time up to 31/3.
No, sorry.
See the
Lord, I
judgment.
leave it to your lordships, my lord, I can.
But we have also
I'm making a request to your lordships. Your lordships feel that.
having got the London Council respecting parties. And considering the request made by the London Council having a contemptors,
My lord, only two and
we
only
grant further 4 weeks time to the contemptors to comply with our earlier judgment in order passed by the High Court to talk on 1st January.
1st Jan.
Sorry, 2nd January.
Then it won't be 4 weeks.
It will be 4 weeks.
We are on 10th of December.
Then, okay,
9th
no
of December.
difficulty. The 16th. 16th January.
Lord, I beg to appear only for the Kuda, that's the Karnataka Urban Development Authority. Therefore, if your lordships kindly say, my lord, they appear only on behalf of respondent 2.
Whoever has to comply with, they have to comply with.
No, my lord, that will be done.
It is ultimately to be done by you.
Correct? No, I appear only for 2.
Sorry.
25.
Notice.
Fine. It's also minor. 24. But the possession is.
Here the problem is
Fine.
that admittedly the possession is not taken because of the built-up area.
Fine.
Correct? At the same time, compensation was also not paid.
Fine.
So
This
that
would be a case where
we can.
My lord, may I submit? My lord, it may be.
You have admitted. No, where is the case of remand? Try to appreciate.
My lord.
Admitted facts. that you did not take the possession because of the built-up area.
My lord, may I submit?
It's a residential complexes are there.
My lord, may I submit? My lord, this may be adjourned by a week. Why I am requesting, my lord? Some other council have filed it. She is in difficulty. Just requested me to be there.
No. But you can't say no.
My lord.
Party, that's not correct.
Not all the matters.
All the matters, my lord, my lord.
It's a very clear case.
My lord.
This is one of those few cases which is covered by.
Only one matter. Only last week we dismissed one matter on the very ground.
My lord, I am aware, my lord. I am aware.
In the facts and circumstances of the case and when.
My lord, that one aspect, if my lords may consider that the substantial portion of the land of the village is.
That is not the point. Point is so far as the admitted position that you did not take the possession.
But my lords have held it in many matters, including the Damini Vadva, which we argued before, my lords. My lord, that if the substantial part of the village is taken, and only that khasra is not taken, my lord, even then, my lord, it is insignificant.
In the facts and circumstances of the case, and considering the fact that even as per the case of the appellant before the High Court, petitioner before the High Court, possession of 4 Viswas could not be taken due to build-up, and even the compensation was not paid with respect to the 4 Viswas of the land. No cases without the interim judgment and order passed by the High Court. SLP stand issued. And see another thing.
My lord.
Total 16 acre Viswas was there.
My lord.
Correct?
My lord.
There was an order to pay the compensation qua only 13 Viswas because you took the possession of 13. There is a specific order passed.
My lord.
That okay, the possession is not taken, correct? They are again, therefore they are not entitled to the 4 Viswas compensation.
3.5 Viswas.
Ah.
Appear to the petitioner in this matter. In the connected matter, Lordship has already issued notice and a stay has been done. I'm saying that this matter be tagged along with the other 2 petitions.
Tag with SLP number 20109 of 2020.
There's also a stay in operation, Lordship.
What stay?
There's a stay in the connected matters, Lordship. I can pass orders to Lordship.
What is the stay? In these matters, anybody is appearing?
Lordship, there is a wakalat filed by the office.
Who is appearing?
Rashi Bansal had filed the wakalat. Today, I'm unaware of
Where
it.
is
In the connected matters, they've entered appearances.
No, in these matters, he has entered. Not yes, okay. SLP 30969 of 2022. On that day, we will hear.
Marshal.
Not a very fine balance which was made in the main order, Lord. It appears, Lord, some unintended consequences which are following now, Lord, by one sentence in the last order, Lord. If I can have just 5 minutes, Lord.
We will not hear. Wednesday.
Better next Wednesday. Very well.
Let it be heard.
Very well.
Lordships are keeping it on Wednesday, Milord.
Yes.
If complaints is filed, let copies be given.
No, next follow.
Yes.
Please, my lord. My lord's in 29 possession and
9.1, my lord's possession could not be taken because of built-up area, but my lord may produce page number 21. My lords, please, my lords, page 21. My lords, the total area is 377 bighas. On 57, the possession certificate is on 59. We've taken possession of 367 bighas. Only the small part could not be taken because of built-up area. So the rest of the whole land is.
What you will do with built-up area?
My lords, that it says so that it will be demolished. My lords, see page 57, my lords.
Please
Not
see.
being built-up area.
First one, the acquisition of is of 89.
Please, my
Award
lords.
is 92.
Please, my lords.
And then the second one, it is even better. Acquisition of 64. Declaration 66. Award 81.
And
My
nobody
lords,
is giving
please.
and built-up area.
Please, my lord, because my lord, what will happen is that if suppose an area has been taken and this area is given away, then tomorrow they may want access if that area has been built up. I can do a thing that we can file an affidavit showing if that area has already been done with the master plan, with the map, because we have been faced with this difficulty, my lords.
What about compensation?
My lords,
Collected or
compensation has been given to the most of the people, but not to these people.
then on what basis are we to say that this? That's not.
Because my lords, the majority have been paid and majority.
We don't know all that. You can't say now. Should I agitate it?
Because it was built up area, therefore it was.
Whatever it is, majority of Delhi is functioning like this, you know.
My lords,
We have 1800 unauthorized colonies which are all on the same footing.
Please, my lords, what will happen is that tomorrow, if suppose they ask us for the easement.
Your government, the government is going for regularization.
Yes.
Nothing is going to happen. Ticket 29.1 है वो earlier order किया है ना हमने. Built up कारण for dismiss.
Your Honor, this is an pollution matter, especially for the state.
You join and file an application for implementation.
Kindly tag this matter.
Not tag, Mr. One another matter was that we dismissing.
The only.
We don't want to. That is the view now. That you join and file an implement application. We don't want to add one more matter.
Kindly mention that in our order, Your Honor.
Present it is Article 32 of the Constitution is not entertained. As other similar proceedings are pending before this court. However, it will be open for the petitioner to move an appropriate application for implementing the present proceedings, which be considered in accordance with law and his own merits. That Jagar,
Exactly.
you are for the
Petitioner.
You is for the state.
For the Judge Power Plant.
You are appealing for the state, no?
No, for Judge Power Plant.
Then you have already allowed it.
Okay, that's similar order.
Who is for the state? Where is that Ms. Gonzalez? Who is that?
Monica Gosai.
Monica?
Gosai.
Gosai.
Monica Gosai.
Just call her. In terms of
Same judgment.
Same judgment.